Hi, in this video, we are going to discuss on the Occupational Safety and Health Act, which is under the module regulations of a certified safety professional exam. So, the Occupational Safety and Health Act, basically it was passed into the law on December 29, 1970. It is also referred as William Steger Occupational Safety and Health Act of 1970. So the purpose of the act was to assure safety and healthy working conditions for working men and women. So this could be achieved by authorizing the enforcement of the standard developed under the act and by assisting and encouraging the states in their effort to assure safety and healthy working conditions. Also by providing for the research, information, education, training in the field of occupational safety and health. So the basic purpose were to set up the enforcement agency to regulate the act and to assist the states to assure the safety and healthy working conditions and providing research and education and training and information in the field of OSH. So the Occupational Safety and Health Administration was created within the Department of Labor. So what were the responsibilities assigned to Occupational Safety and Health Administration? So the first was to encourage the employers and employees to reduce the workplace hazard and to implement new or improve existing safety and health standards. The other responsibilities was to establish separate but dependent responsibilities and rights. So it should be given stress that the responsibilities and rights are dependent as well as they are separate for the employers and employees. Then the other responsibilities are like maintaining a reporting and record keeping system to monitor job related injury and illness. The main purpose was to maintain the statistics. Then to establish the training program to increase the number of competent occupational safety and health personnel. Also to provide for the research in occupational safety and health and develop innovative way. And to develop the mandatory job safety and health standards and enforce them effectively. So these were the main purpose of the Occupational Safety and Health Administration. So the first was to uh, implement and improve the existing health and safety standards uh, and then to establish the roles and responsibilities and rights, then to maintain the statistics by reporting and record keeping system, then to establish the training program and provide research in the field of OSH and also uh, develop the mandatory job safety and health standards and to enforce them. So who is covered under the Occupational Safety and Health Act? So all private sector employers with one or more workers, all in the 50 states and US territories. They do not apply to all the employees in public sectors like municipal, county, state, or federal government agencies. They do not apply to self-employed individuals. They do not apply to family members operating the farm. They do not apply to domestic household workers. Now, the standards are horizontal standards and vertical standards. So, the horizontal standards are those standards that apply to all industries and employers. For example, fire prevention and protection standards are horizontal standards, which are common to all the industries. Vertical standards are those standards that applies only to the particular industries and employers. Standards that apply only to the construction industries are example of vertical standards. So if the standards are specific to the nature of the industry, then they are called vertical standards, and the standards which are applicable to all the industries are the horizontal standards. Now next is the general duty clause. So each standards promulgated by OSHA cannot cover every specific details. Therefore, OSHA has implemented a general duty clause into the regulation. The general duty clause states that an employer shall furnish a place of employment which is free from recognized hazards that are causing or likely to cause death or serious physical harm to its employees. Where there is no specific standard, OSHA will use the general duty clause for the issuance of the citations and fines. Citations is the violation notice. So the general duty clause can be found in section 5A1 of the Occupational Safety and Health Act of 1970. So every detailing of the hazards, or we can say every detailing of the hazards specific to the industries which cannot be made possible comes under the general duty clause. So the general duty clause is applicable by default to all the workplace, or it's applicable to the employers. Where there is no specific standard, the OSHA will use the general duty clause for the issuance of the citations and fines. Now we will see under OSHA what are the employer's rights and responsibilities. So beside meeting the intent of the general duty clause, the employers must examine the workplace condition to make sure that they comply with the applicable standard. So they need to uh, know what are the standards applicable to their specific nature of job. Then to minimize or to reduce the hazard. The employer should make effort to minimize or reduce the hazard. Then the employer should use color codes, posters, labels, or signs when needed to warn the employees of potential hazards. The employer should provide training required by applicable OSHA standard. The employer should keep OSHA required records. And the employer should provide access to the employee medical records and exposure record to the employees or their authorized representatives. So to summarize this, the employer should uh, first out evaluate his workplace for the applicable standard. Then he should minimize and reduce the risk. Then he should warn the employees of the potential hazard by use of color codes, poster labels, and then provide training as applicable by OSHA standard. And he has to keep all the OSHA required records, and he has to keep the medical records and access to the records to its employees or their representatives. Now, what are the employee rights and responsibilities? So the employee should read the OSHA poster, follow the employer's safety and health rules, and wear or use all the required gears and equipments. The employee should follow the safe work practice for the job as directed by the employer. The employee should report the hazardous condition to the supervisor or safety committee, and the employee should report the hazardous condition to the OSHA if employer does not fix them. And the employee should expect safety and health on the job without fear of reprisal. So now, what are the OSHA's inspection and the process? So whenever an OSHA inspection occurs, the employer must be advised by the compliance officer of the reason for the inspection. Also, the employer may require identification of the OSHA compliance officer, and the employer should accompany the compliance officer on the inspection, and the employer should be assured of the confidentiality of any trade secrets observed by the OSHA compliance officer during an inspection. The compliance officer also has the right under the law for timely admission to the facility. Any unnecessary delay or refusal of admittance may prompt the compliance officer to obtain a warrant for inspection purpose. So, the employer should first the compliance officer visiting the employer should give the reason for the inspection. Then he must show the identity of his being a compliance officer, and the employer should accompany the compliance officer for the inspection. Excuse me. So now, under the OSH Act, under the OSHA Act, the OSHA is authorized to conduct the workplace inspection during normal operating hours. The inspections are based on the following priorities. The first is the imminent danger situation, then the catastrophes and fatal accidents, then employee complaints, then programmed high hazard inspection, and follow-up inspection. Excuse me. So these are the various priorities of the inspections. Now we will see the inspection process, how the OSHA conducts the inspection. So the compliance officer first prepares himself or herself by becoming familiar with the particular industries and business through the research. He or she will be familiar with the potential hazards and the processes involved with that particular business. Once the authorized credentials have been presented, The compliance officer will hold an opening conference. In the opening conference, the compliance officer will explain the purpose of the visit, how your particular facility was selected for inspection, the scope of inspection, and the standards that will apply. The compliance officer will ask the employer to select an employer representative to accompany him or her on the inspection. The Act does not require an employee representative to accompany the compliance officer. After the opening of the conference, the compliance officer conducts a walkthrough inspection of the facility. Once the compliance officer has completed the walkthrough inspection, he or she will hold a closing conference. During the closing conference, the compliance officer gives the employer and all other interested party a copy of the employer's rights and responsibilities following an OSHA inspection, that is OSHA 3000, for the review and discussion. The compliance officer then discusses with the employer all unsafe and unhealthful conditions observed during the inspection and indicates the violation for which he or she may recommend a citation and the proposed penalty. Citation means the violation notice. At this time, the compliance officer will also inform the employer of the appeal processes. So now, what means we will see the OSHA citation. So after the compliance officer files his or her report with the area director, it is the area director who determines whether he or she will issue a citation or propose a penalty. The area director will send all citations via certified email. Once the employer has received the citation, they may post the citation for 3 days or until the violation has been abated, whichever is longer. So now we will see the various OSHA citations. So the category of violations are: first, the serious violation. So the serious violations are the violations where there is substantial probability that death or serious physical harm could result. Then the next category is the other than serious violation, a violation that has direct relationship to the job safety and health but probably would not cause death or serious physical harm. Then next is willful violation, a violation that the employer intentionally and knowingly commits. Next is the repeated violation. So the violation of any standard, regulation, rules, or the order where upon re-inspection a substantially similar violation is found and the original citation has become a final order. Then the next category of the violation is failure to abate violation. Failure to correct a prior violation. The next is the potential and other penalties. So additional violations for which OSHA may issue citations and propose penalties. Now we will see what the appeals the employer can have. So once a citation or a non-citation is issued, an employee or the employer may appeal the decision by the area director. The appeals process is different for the employer than it is for the employee. Now first we will see employee's appeal. If an employee complains, initiates an inspection, the employee or authorized employee representative may request an informal review of any decision not to issue a citation. Employees may not contest citation, amendment to the citation, proposed penalties, or lack of penalties. Context here refers to the challenge. So the employees may not challenge the citations, amendment to the citation, proposed penalties, or lack of penalties. They may, however, contest the time allowed for the abatement of the hazardous condition. So this is only the appeal which employees can do. Employees must contest the petition within 10 working days of its posting or within 10 working days after the authorized employee receives a copy. Now, the employer's appeal. Within 15 working days of receiving a citation, an employer who wishes to contest must submit a written objection to OSHA. The OSHA area director forwards the objection to the Occupational Safety and Health Review Commission, which operates independently of OSHA, which is also known as OSHRC. The OSHRC is a commission of three-member administrative law judges appointed by the President of the United States with the consent of the Congress. When issued a citation and notice of the proposed penalty, an employer may request an informal meeting with the OSHA's area director to discuss the case. The OSHA encourages employers to have informal conference with the area director if the employer has issue arising from the inspection that he or she wishes to discuss or provide additional information. The area director is authorized to enter into the settlement agreement that revises citations and penalties to avoid prolonged legal disputes and results in speedier hazard abatement. Now, the petition for the modification of the abatement. So, a petition is a plea. So, after receiving a citation, the employer must correct the cited hazard by the abatement date unless he or she contests the citation or abatement date. The factors beyond the employer's control, however, may prevent the completion of the corrections by the date. In such a situation, the employer who has made a good faith effort to comply may file a petition to modify the abatement date. The written petition by the employer must specify the steps taken to achieve the compliance, then the additional time needed to comply, the reasons additional time is needed, the interim steps taken to safeguard employees against the cited hazard during the intervening period. The employer must certify that he or she posted a copy of petition in a conspicuous place at or near each place where the violation occurred, and that the employee representative received a copy of the petition. Now, the notice of the contest. If the employer decides to contest either the citation, the abatement period, or the proposed penalty, he or she has 15 working days from the time the citation and proposed penalty are received to notify the OSHA area director in writing. Failure to do so result in the citations and proposed penalty becoming a final order of the OSHRC without further appeal. An orally expressed disagreement will not suffice. This written notification is called notice of con- contest. So the employer has the 15 working days after receiving the citation and the penalty, to notify the OSHA area director in the writing about the contest he wants to make about of the citations issued. Otherwise, if he fails to do it, the it becomes the final order of the OSHRC, which acts independently. Excuse me. OSHRC acts independently of the OSHA. So it will be, if once become the final order, no further appeal will be entertained. So this should not be expressed orally, but it should have a written notification, and this is called notice of the contest. The employer must give a copy of the notice of contest to the employee's authorized representative. If any affected employees are not represented by the recognized bargaining agent, the employer must post a copy of the notice in the prominent location in the workplace or give it personally to each unrepresented employee. Now, review procedure. If the employer files a written notice of contest within the required 15 working days, the OSHA area director forwards the case to the OSHRC. The Commission is an independent agency not associated with OSHA or the Department of Labor. The Commission assigns the case to an administrative law judge. OSHRC may schedule a hearing at the public place near the employer's workplace. The employer and the employee have the right to participate in the hearing. The OSHRC does not require them to be represented by the attorney.